control now.
Try now, Rich.
There we go. All right, looks like I've got it now.
Okay.
All right, so on the, as I said, on the lower right-hand side of your screen, you're going to see at the bottom of your GoToWebinar panel a place for you to enter questions, and we'd like you to do that and be very interactive with us as we go through the webinar today. So if you've got a question, go ahead and enter it in the question box, or if you've got a chat box, you can enter it in there. But the most important thing is we want you to get involved. So what I'd like you to do right now, if you would, in the questions box or in the chat box, just type in your name and where you're from. We'd like to kind of get an idea of geographically where everybody's from and who's hanging out with us today. So we're going to go ahead and get this thing started, and I want to introduce you to my colleague Paul Sheldon, who is now going to take you through what we're going to be covering in today's webcast.
Hi, everybody. It's great to be with you. I'm excited to have a chance to do this with Power Sports Business. And as Dave said, I've been in the business for a long time, and it's really just kind of fun, even though it's compliance and that all sounds kind of boring. I think we can make it kind of fun and just really focus on the few things that we need to pay attention to as Power Sports dealers. So we don't have a lot of time today, but what we're going to talk about fit into these three categories. First is, where do you start a compliance program? It can seem overwhelming, but if we just drill it down to a couple of important things, I think that we can grab a hold of those, make sure that you're in compliance, so that if there ever is any audit or visit from any officials from CFPB or FTC, you'll be able to stand up to those just fine. A dealer action plan. What are the first things that I need to do? And then ultimately making sure that you have the 5 elements of the information security program in place in your dealership as soon as possible. So those are the overarching things that we're going to talk about. So, Rich?
All right, great. Thanks, Paul. And the first thing we have to do, good old notice, please note, and I'm going to read this verbatim just because I can, please note that this webcast on compliance is intended to be a general summary and a guideline. It's not intended as a substitute for your dealership's legal counsel, but you're going to find as we go through this that your legal counsel is going to be very much involved in helping you make sure that you are strictly in compliance. So let's start this whole thing and take a look at what's going on with compliance really. What is this all about? Well, the first thing that we've got to deal with compliance is it's going to have to start from the top. And by the top, I know that you may be an F&I manager on this one, you may be a general manager, you may be a dealer principal, but to get your F&I compliance working the way it should, it's going to have to start at the top. And the leadership of the dealership should be the one who starts it. Now, that doesn't mean that they can't delegate things to their compliance officer or to other people that are designated in your policies and procedures, but it's got to start at the top, because if the dealer principal doesn't have a strong affinity for compliance, it's going to be very hard for everybody to deal with on down the line. And as a really good example, my daughter is a title clerk at a dealership here in St. Louis, where I'm from, and I asked her as we were putting this together, I said, when you took over as title clerk, did anybody take you through compliance and what you were allowed to do and what you couldn't do and what information you could share and who gets to read the credit reports? And she just looked at me and said, no. I'm like, okay, well, and this is a pretty reasonably well-known dealership, so it's got to start at the top. Now, the next thing that happens is when you start from the top, you're going to put the policies and procedures that are in place. And we're going to take you through some of them today, but there's some additional information that you can get from AFIP, and Paul may talk about them a little bit later on. They're a partner of ours and also of Power Sports, and it's important that you put these policies and procedures together well. Now, here's the key point around that one. When you've got your documentation in place and you've designated your compliance officer, everybody knows what they're supposed to be doing, you're doing your audits on a regular basis, people are being trained effectively when they come in, and you're doing your disclosures, adverse action, all of the different disclosures, consumer credit reports, all those types of things. When you're doing your disclosures properly and you've got your documentation in place, now you have a defendable compliance policy at your dealership. Now, will it be 100% airtight? Who knows? But if you ever, as Paul said, get have the CFPB knocking on your door, the FTC, at least you've got a very dependable compliance process already set for you, and you can take it from there. So that's kind of the big setup for how you're going to have to be involved and what the dealer's responsibilities are. But the key thing is you want it to be defendable. So now Paul's going to take you into a little bit of the nitty-gritty and talk about the treatment of non-consumer public information, or NPI.
So consumer non-public information, we call it NPI. The slide here says that it's personally identifiable financial information that a financial institution collects about an individual. We are in the business of collecting that information anytime we're helping somebody finance a bike or something that we sell. So we're very much involved in the collection of non-public information, and there's a lot of rules about how it is that you're supposed to treat that. I've been in a lot of dealerships where it is not very hard to find a credit app laying on a salesman's desk, or a computer screen that's opened to a credit report, or someone's information about where they work and how much they make. All of that is non-public information, or NPI. One of our dealers asked a question that I think is really helpful in guiding us here. They said, what specifically, if anything, can a salesperson keep in their office as far as NPI is concerned? And the answer is, really, there isn't anything in the salesperson's possession that's considered non-public personal information. They should have nothing on their desk. So public information is something you can find in a phone book or online about a person: name, address, phone number. Things like driver's license numbers, social security numbers, birth dates, income, place of employment, alimony, etc. That's all non-public information. And there is even talk now of email addresses and cell phone numbers that are not published being considered as NPI. So the most important thing to know here as a retailer, as a finance person, is you're dealing with customers' information that they don't share with very many people. And there's a level of trust that's given to you that you need to honor in making sure that that information is very safe. Number one crime in America right now is identity theft, and a lot of it has stemmed from, well, frankly, thieves getting a hold of non-public information and using it to their advantage at the detriment of a customer. My wife and I just went through that with our bank account, and it took us a month to get it reconciled. Someone had taken a debit card number and used it to buy some things that we didn't authorize. So it's a very real thing, and so we have to be very aware that this is going on. So another way to look at this now, when someone comes in the store, it's easy for me as an F&I person to make sure that I lock things up and I keep them clean. But what happens when they're on the internet and they're wanting to make purchases? We're selling a lot of product over the internet. What are the rules for obtaining credit information over the phone or over the internet? Let me walk through just a couple of things with you quickly. First of all, if a dealership is going to obtain credit other than in person, the first attempt that you should do with your customers is to have them submit an application over your dealership's, it's called Secure Socket Layered, SSL, an encrypted website, your online application. Two reasons, very specifically. The first one is obvious. You have encryption security on your website. The second reason is the customer has to click through and accept the dealership's privacy policy before electronically signing it or submitting the application for credit. So that's online. If it's over the phone, then you need to very specifically ask the customer if it's okay to take the credit information over the phone, and then if they can obtain, or if you can obtain a credit report, you need to get their information. You accept the verbal authorization, and then you mark on the credit application that you have received. You write this down: verbal authorization to run credit, and you put the date that you received it. Ultimately, when the customer comes in to finalize the transaction, pick up the bike, they need to sign a hard copy of the credit application. If for whatever reason you're delivering this out to them and they don't come in, then they need to mail a copy. You need to mail them a copy of the privacy notice, the credit score notice. Sometimes we call that the risk-based pricing notice, and an adverse action notice to the customer as well. So those are a lot of things that are going on with non-public information, and we're going to come back to this a little bit and talk about how you make sure that it's being handled well in your store. So Rich is going to take us through an example of actually an auto dealership where they ran into some trouble specifically with this online.
And so this is something for everybody to be aware of, is that not only, as Paul said, taking credit apps over the phone or online, the electronics age has really opened up some new and interesting things. And I'd be willing to bet that if we did a poll or a raise of hands right now, every one of you would say that you've got some sort of a smartphone, you're on it all the time, you're maybe on a tablet, you've also got a laptop computer, and the tendency is to want to take work home with us if we can. And that's something that you really shouldn't be doing, and the reason why is going to be shared in this case study of Franklin Toyota. Now, I know this is a power sports audience, and as Paul said at the top, we haven't really been bothered yet in power sports that much by CFPB and by the FTC, but I want to share this case study with you because it's something for you to think about. And I know a lot of you have got younger salespeople or younger folks who are digital natives. They grew up using their phones and everything. So here's something for you to think about. What happened with Franklin Toyota for this case study is they were charged by the FTC saying that they compromised customers' personal information, and what they had done was allow P2P or peer-to-peer software to be installed on the network at their dealership. And this resulted in a lot of personal, sensitive NPI, a lot of financial information being uploaded to a peer-to-peer network. Now, for those of you who remember back a while, you may remember a site called Napster, and it was a peer-to-peer site. And what it was designed for, and a lot of us did this, went out and you brought down music from the Napster site where they had gotten it, in some cases legally, in many cases not, and we were downloading a lot of songs and information. Well, that's how a peer-to-peer network works. Now, where Franklin got into trouble with the FTC, because they lease cars and they provide financing for their customers, their privacy policy said we restrict access to non-public information about you to only those employees who need to know that information, to provide products and services to you. We maintain physical, electronic, and procedural safeguards that comply with federal regulations to guard non-public information. Here's the problem. The FTC alleged that Franklin failed to implement reasonable security measures to protect this, because what happened, information for 95,000 consumers was made available on a peer-to-peer network, including names, addresses, social security numbers, dates of birth, and driver's license numbers. So here's what caused that. One of their employees decided that they were going to take a bunch of work home from the dealership with them to work on them that night on their laptop. And they downloaded it onto a flash drive, one of those little USB thumb drives that you can stick into a computer or you can use with an iPad. And to take that a step further, looking at things like cloud sharing, maybe it's Google Docs or any of the online things like Dropbox, would fall under the same category. Well, what happened was they took this flash drive home, installed it on their computer at home, and their computer had peer-to-peer software on there that triggered the breach. And what's interesting is none of the dealership's computers were ever loaded with the peer-to-peer software, but when the employee stuck that flash drive into their computer, peer-to-peer network picked it up, and it was now available to anybody who happened to be on that peer-to-peer network. So there's a lot of different ways it can be used, peer-to-peer, such as to play games, online calls, file sharing services. I just talked about that. But the FTC has found P2P software can pose significant data security risks. A 2010 FTC examination of P2P related breaches uncovered a wide range of sensitive consumer data that's available on P2P networks. So here's the warning from the Franklin Toyota case study. Do not take information home from the dealership on any kind of device, especially if you've got any kind of peer-to-peer software at home, or you may also want to look at your dealerships and make sure that nobody's downloaded any peer-to-peer software onto the dealership's computers also. Now, the trick here, generally a file that's been shared can't be permanently removed from a P2P network. It's like they've always said, once it's out on the internet, it's always there. So, very important for you to be aware of that. Now, we're going to take that and tie it into taking a look at what comes next with the Gramm-Leach-Bliley. And Dave, looks like
Gramm-Leach-Bliley, thanks, Rich, is it's the congressional bill that drives all of this regulation. And then from that, we've seen of course, we have the FTC, but then we had the creation of the Consumer Financial Protection Bureau, which came actually under another act called the Dodd-Frank Act. But all of this works together, and it's all driven by this original bill. And basically what it says is the provisions that are in it affect the insurance industry, the automotive, RV, power sports, marine business, to the extent that our business is involved in extending credit and issuing insurance. And most of us are in the business of getting our products financed. So it creates an obligation for all of our dealerships to protect the confidentiality of consumer information. Here's an example. Every one of your dealerships is required to give a customer a privacy notice. And there's a couple of different ways to do that. When you're completing a credit application, if you get the driver's license number, insurance information, social security number, or date of birth on the face of the purchase agreement, it's a good time to give the customer your privacy notice. Sometimes they're not given out until the finance office is with the customer. A lot of dealerships now are starting to err on the side of caution, and they give the customer a copy of the privacy notice when they commit to purchase the bike. So in the sales process, or at the end of the sales process, rather than later in F&I process, so that the dealer is never open to any kind of challenge that the customer would say, well, they never gave me that notice until they've already got all of my information. So we want to get that as soon as we can, and frankly, the sooner the better, and you start moving them down the road of having compliant paperwork. We're going to take a look now, too. Rich is going to walk us through a little bit of what the safeguards rule is at this time. This also comes out of Gramm-Leach-Bliley. And then on our next webcast, we're going to be talking about red flags and compliance manuals and such, of those kind of things. But today, Rich is just going to talk briefly about safeguards rule.
All right, so the safeguards rule is a part of Gramm-Leach-Bliley, and basically what the safeguard rule says is that anybody possessing NPI need to develop, implement, and maintain a written, and there's the key phrase there, folks, is written, a written information security program, or ISP, that contains at least a broad outline of information security policies, procedures, and safeguards. This requirement that they're talking about here is going to fall on any dealer engaged with any financing or insurance transactions. So that's almost all of us in this particular world. So maintain and implement a written information security program. And again, I'm going to do a little shout out to AFIP, and you can go to their website and find a package that they have that has basically fill in the blanks and the ability for you to create your ISP from there. So what are some of the things that a dealer needs to do around their information security program? Well, first, it needs to be a written program. because that's one of the first things they'll ask for if they ever come knocking on your door is, can we see your information security program? Part of that, and the next critical piece, is for you to make sure that your dealership has designated a corporate compliance officer. Now, this is usually going to be someone in a position of leadership, and I would encourage you to talk with your dealership's counsel, legal counsel, about what level of your organization that needs to be. But the corporate compliance officer is going to be somebody who's involved with your information security program on a very regular basis. The next critical piece is you need to maintain and have a written record that all of your new employees that have any type of safeguards responsibility have all been properly trained. So start with your information security program, check with your corporate counsel, make sure that you designate a corporate compliance officer, and there's more information if you just research that on the FTC site about what exactly they're going to do, and then make sure that all new employees with safeguards responsibilities have been properly trained. And if you find yourself after this webinar going, wow, we've never done that before, I would extend that beyond just any new employees who are being hired and take it all the way back to everyone who is currently at the dealership and take them through the training for compliance, the safeguard rule, Gramm-Leach, Bliley, and things like that. Now, what do you want to look for, and what do you need to make sure that's there in case they come knocking on your doors to talk to you about it? Well, they're going to look to see when was the last time your ISP, your information security program, was updated to make sure that you're staying on top of what's going on. And the Power Sports Business folks have a lot of great articles in the magazine every month on all types of different compliance things throughout the year, and it's a great way for you to stay on touch with that. The other thing you might want to do is set up some Google alerts to alert you to, say, changes to Gramm-Leach, Bliley, or changes to the safeguard rule, or compliance and the CFPB, and that will alert you to stuff that shows up on Google and anywhere else, and it's a great way to do it. Second thing to look for is, are any documents containing non-public personal information? Right? Paul talked about it. Deal jackets, credit apps, driver's license, photocopies, all that kind of stuff. Are they properly protected? And one of the biggest things I see when I go into dealerships, and in fact the last car that I bought, I was walking through the finance office and there were copies of somebody's driver's license just thrown in a trash can. So that right there was a major violation. And if you want to really see if you're up to speed on this, ask someone to just walk through your dealership, and if they see any NPI, just pick it up and bring it to the dealer principal or the GM. That way you've got a good idea of how much is already out there, what the challenges might be at this particular point in time. Then, and this is the one I talked about with the Franklin Toyota case study, is you want to make sure that smartphones, iPads, jump drives are very tightly controlled with what information your employees are allowed to put on them, and it should be none, and none of the NPI should be leaving the dealership. Now, there's a couple of things we've got pre-questions that came up that Paul's going to talk about in this next section, where we start talking about putting together your 5 elements of an information security program. Now, this is not an in-depth dive into everything that has to be in there, but it's a nice overview for you of 5 of the top things that you're going to need to worry about when you're putting your ISP together. Paul?
Okay, so thanks, Rich. And we're going to go through these just as an overview of what the information security program needs to contain, and these need to be in your compliance manual. And the first thing, as Rich mentioned, is you need to have an employee who's designated to coordinate the program. That's called a compliance officer. You can't outsource it to someone who's not an employee of the dealership. You know, a lot of dealerships, when I meet with them, say, well, I'll just have my F&I person be that person, because the F&I person's involved with all of this NPI. And one of the things that we would encourage is that it's actually not the F&I person, because they have so much responsibility of this information anyway, and it's always good to have a second pair of eyes on these kinds of things. Like Rich mentioned, I can just take a copy of a driver's license, and instead of properly disposing of it in a shredder, I end up just tossing it in the recycle bin next to the copier. Those types of things. So designate someone in the dealership who has this as their responsibility. You don't have to hire someone full-time for this job. This can just be added to someone else's responsibilities to be able to do this. But it's absolutely essential that you have an employee designated to coordinate the program. That's number one. Number two is then you need to identify reasonable risks to the security of the customer information. Now, if we just look at the F&I office, it's probably one of the most sensitive areas that we look at. So, again, examples of documents that contain NPI, customer's driver's license, insurance cards, credit applications, credit bureau reports, worksheets, bank callback sheets. If you've got fax documents that are coming, proof of income, credit insurance applications that would disclose health history, those types of things. So very important that those things are kept, frankly, locked up. And it isn't okay to have it just in a folder on a desk. I can't tell you how many dealerships I've been in where I got 6 deals sitting on the floor. They're all in deal jackets, but they're not locked up, and there's nobody around. And it was very easy to walk out with that information. So that's first thing. The second thing is computers should all have password protection on them. And one of the things that is just kind of a trigger is make sure that when you leave your computer, if you're the finance manager, that it goes to your locked screen very quickly. I think mine goes to a locked screen in probably 30 seconds. And I know it's a pain, you got to put the password back in, but that locks it down so that your information that's on there, because you're working with so many different venues, that keeps it safe. When you're not in your office, lock the customer information up. And I would encourage you, lock a drawer, and frankly, when you leave your office, lock your office. That is super secure, and it just keeps it safe. And with compliance, you want to err on the side of making sure everything is safe. The third part of that is compliance training. And as Rich said, it's important to train new people. I would tell you that it's important to train everybody at least every year, because you're going to update your information security program year. When we talked about making sure that the information is kept current, if you're updating it annually, you're probably fine. And so you just have a once-a-year training for everybody, refresher, because some laws are going to change. They're going to add something else to it. The CFPB, FTC, all of these guys, they continue to move this forward. And by the way, if you think this is new, this whole process of safeguards and Graham-Leach-Bliley, all of this was passed back in 1990. Full compliance was required in 2001, and even though they pushed back enforcement for several years, that doesn't excuse anybody for not being on top of it. So we're a little bit behind the 8 ball, but we want to make sure that we move forward as quickly as we can. So training everybody, office, title, sales, finance, service. You can take a trade, and then your tech or your service writer, service manager, ends up with a pile of paperwork from the customer that may include non-public information. There needs to be something in your information security program, your compliance manual, that tells them exactly what it is they're supposed to do with that. Okay, one of the questions that I got from one of our online questions during this seminar is from a finance person who said, listen, how detailed can we share consumer credit information and credit report history with the customer and with other dealership personnel? So this is a really tricky area right now, and I think I mentioned before that identity theft is climbing, and it's pretty much out of control. You've seen the major breaches that have happened with information and credit cards and department stores and such. So the answer is this: is technically an F&I person can share the information that's in a credit bureau report only with the person who's applying for the credit once you've identified that the person sitting in front of you is the person they say they are. So you've verified their identity. The customer in your dealership is not entitled to a copy of the credit report from the dealership. If they want to get a copy of the credit file, they can go to a website, annualcreditreport.com, and they can download their own report. And the law changed a few years ago. You're entitled to a free copy of your report once a year. Now, salespeople are definitely not on a need-to-know basis when it comes to credit report. But there are some circumstances where F&I will talk to sales manager, perhaps if you're wanting to spot deliver a vehicle and it's on the weekend, and so you're going to review those points together to make sure before you do that that you've got a customer that you can get financed on Monday. Okay, so that's number two. Number three now, you must design and implement customer information safeguards through risk assessment and conduct regular compliance audits. So this then would be the kind of the responsibility of the compliance officer on a regular basis. Every 6 months, if there's a big change in personnel, annually is probably enough. If you have everything in place, now you're just reviewing and you're checking the various departments to make sure that everyone's in compliance. And number four, you must oversee compliance of your service providers, the people that you do business with. So the banks, credit insurance companies, service contract companies, your other vendors. Because if they're in non-compliance with protecting NPI, the dealership is liable. So make sure that the agreements that you have, that the service providers are in compliance. And I know with our company, we're very, very aware of the importance of that, and we make sure that we take very good care of our information. Number five is, now you're going to have audits. So based on the results of your audits, you need to make any adjustments that you see. So having safeguards in place is not an option. It has been the law for many years now. We've seen enforcement at a very expensive level in the auto business, and we're starting to see audits beginning to happen in the power sports business as well. And I see it in marine and in RV. We're having these same discussions in those industries as well. So that's a very quick overview of the 5 elements of information security program. Have them in your compliance manual, managed by your compliance officer, and you'll go a long way toward making sure that your dealership is in compliance, your customer information is safe, and the dealership is secure. So, Rich?
Excellent. Thanks, Paul. And at this point in time, we're going to go back to Dave and see if there are any questions that we need to take care of, and then we'll get into a couple of key takeaways for you from today's webinar.
Actually, yeah, there were a couple of questions. The first one was just about authorization, and one of the dealers wanted to know if an email authorization was okay.
An authorization for credit? For credit?
Right.
Yeah, again, when the customer comes in to take delivery, then you can get things signed off on. But having it at least in writing is, it's the same as having the verbal information, although you do have an email, so that can go in a file and that can work. I think the key there is when they come in, just to make sure that you've given them the privacy notice, the risk-based pricing, et cetera. So that if you're doing all of that over email and delivering the unit without them coming into the store, then you need to make sure that you've got certified mail and such going on to deliver those documents.
Sure. And then another was, what if a bank pulls credit and a dealership does not?
Sorry, what's the question then?
Yeah, they're just asking if the bank pulls the credit rather than the dealership.
Oh, so is the dealership liable for protecting the information?
Yeah, I assume that.
The answer of that is always going to be yes. The dealership is always responsible for protecting information, and that goes back to that. Make sure that you have agreements in place with the suppliers and the vendors you do business with, that they're protecting the non-public information, and you need to make sure that you're protecting it as well.
Perfect. And then another one is, will the verbal authorization statement protect the dealership in the event that the person is giving them fraudulent information?
Rich, you want to take that one?
All right, read that question one more time. I want to make sure I heard it exactly right.
Sure. Will the verbal authorization statement protect the dealership in the event that the person is giving them fraudulent information?
It will provide limited, because one of the things that and we're going to talk about this in an additional webinar, is the dealership is responsible for watching for things that would fall under the red flags rule, and that's where fraudulent information or a fraudulent ID is going to come into play. So if the dealership goes far enough and asks those questions, they've made a good start at it. But the reality of it is that is probably not going to suffice, just having the verbal, especially if it's something that is dealing with fraud or identity theft and things like that. And again, that's part of red flags. And so the quickest thing to do is, if you want the exact verbiage on it, is to look up the red flags rule on ftc.gov. But it's a start when you ask for it and you document it, just like we've been talking about. Will it hold up completely? I doubt it.
Okay. And another one is, they're asking, what's the website you just referred to? It was just a series of letters that might have been difficult to
Sure.
understand. Yeah, what was that site?
It's www.f as in Frank, T as in Tom, C as in car, .gov. G as in golf, O as in Oscar, V as in Victor.
Sure, and there's another one you referenced that also escaped me. I believe it might have started with an I. It was one of your partners.
Oh, AFIP.
Yes, AFIP. That was it. Yep.
www.afip.com. Okay. The association. Okay, Paul, you do it. I never get the letters right. AFIP
this is the Association of Finance and Insurance Professionals. Their whole business is helping dealers and F&I people to be in compliance, and so there's a certification that runs through them, and they're on top of this pretty much on a daily basis. I'm senior certified with them, and it's one of those things that you just keep current on in our business, so that you're aware of the latest changes, and you can stay ahead of them.
And Paul, I think it would be my recommendation, and probably yours, that if a dealership really wants to do their compliance well, it's probably not a bad idea to send at least one person from the dealership through AFIP certification training, just so they've got somebody who's a little bit more in depth on what's going on there. And by the way, gang, not a plug for AFIP. We're not getting anything out of this. We just know that they are the best training agency for helping you get up to speed on your compliance. Would you agree with that, Paul?
Yeah, I would, and again, just so it doesn't sound like an endorsement, there's several of those companies out there. I've worked with that particular company for 20 years, so I'm familiar with them.
Yeah, and then the next one, you guys sound like you answered. Can the designated officer be the F&I manager, or does it have to be someone other than F&I?
Yeah, it can be F&I. Kind of the recommendation, I suppose, is that it probably is best if it's not, just because you've got the F&I manager handling all of the paperwork, and so having a second set of eyes on it is to the dealer's advantage.
Cool. Let's see. We do have a handful more. Would it be a violation if a customer deal is revisited by the F&I manager at a later date after it's been filed, or revisited by a salesman? Would it be a violation if a customer deal is revisited by the F&I manager at a later date after it has been filed, or by a salesman?
I think the key there. Oh, go ahead, Paul.
No, go ahead, Rich. That's fine.
The key there is the F&I personnel Yes, that won't be a problem because they are using the non-public information to help secure a loan, to help make sure that the deal goes fine and all that kind of stuff. The salespeople should really have no access to any of the NPI at all, just to make sure you're perfectly safe. But for an F&I manager to go back, look at a deal jacket, and check the information is perfectly fine, but not the salespeople.
Excellent. And we'll just keep running down our list here. From the issues you have discussed, do lenders share any of these risks? Do they share any of the responsibility for dealership noncompliance? Looking at the lenders.
Paul?
The dealer can't lay off their risk of noncompliance to the lender. The lender's responsible for compliance for themselves, but they're not responsible for the dealer's compliance. That's why it's really important that everybody's kind of on the same page and really taking care of the customer information.
All right. And moving on, we have one. We don't run credit reports in-house. We send out, for example, to different banks that are listed. We just get back an approval with an interest rate. Our salesperson takes that sheet and tells the customer their approved rate. Is that a problem?
That shouldn't be, because it doesn't deal with any non-public information or personal information. And again, to what Paul was just talking about, because the bank is the one who ran the bureau and got all of the information on the customer, they're going to be charged with safeguarding and make sure they're doing compliance on that particular set of information. And if the sheet that you get back from the bank has nothing more than you're approved, you're not approved, and here's the rate, it really doesn't contain any NPI unless there is something like a social security number or something that would not normally be considered public information. So the bank will have that responsibility, and as Paul talked about earlier in the webcast, check with your vendors. They should all have something in place that deals with all of this compliance, especially the banks, because they're being watched even more heavily by CFPB and others than the RV industry, the power sports industry, the auto industry. And so they're going to have it in place, have those procedures in place, but it certainly wouldn't hurt to talk to all of your vendors and see what they do have in place.
Excellent. Some more questions here. The ISP manual is completely separate from our red flag book, or is the red flag manual to be part of the ISP?
You know, if they're in the same binder, I don't think that that's a problem. They address two specifically different issues, but my guess is your compliance officer will be aware of both.
Okay.
Yeah, and actually, if you build your ISP correctly, you can include all of that information on red flags, on safeguard, on Gramm-Leach-Bliley. All of that information can be contained inside of your information security program, because people are going to have to reference that at some point in time, or it may be used for training.
Awesome. I want to thank the F&I folks for all the questions here, just like you've heard 1,000 times. Everybody else probably has the same question, so these have been awesome. And we appreciate the participation and attendance once again. Another one is, can I take credit applications over the phone?
Yeah, with permission from the customer, and you need to document that and verify it, and then have the customer come and sign documents. We covered that a little bit earlier, but it's important that that the privacy notices, risk-based pricing, and those other forms are also communicated to that customer. So yes, you can take credit over the phone. You just need to make sure that it's well documented when the customer comes in, that you kind of backfill what you missed on the phone.
And also make sure that, you know, if you're going to take it over the phone, make an attempt at first to have them submit the application via a secure website. So an application on your dealership website or some other secure website is the next best way to go, and try to get that first, and then go to the phone if you have to.
Yep, and then remember, when they come in, get a signature on a hard copy of the credit app.
And next one is, are we legally allowed to make copies of military IDs?
Yes, as long as they're handled just like a driver's license or social security card or anything else. That's non-public information, and it has to be handled the same way.
Next is, should we give the customer a copy of the risk-based pricing notice or just have one signed on file?
You know, you always, again, you want to err on the side of you know, making sure the customer is well informed. So you can have one on file, and I can tell you, different dealers do this differently. Some will put it on file, other ones will give it to 100% of their customers.
Okay, excellent. Is there a written form of today's webinar? There's not going to be a written form, but we'll have the entirety of the presentation on our YouTube page, powersportsbusiness.com. You can just go there and find our YouTube link. Let's see here. My question, let's see. You said the salesperson shouldn't have credit report info. We aren't getting the report. We are just getting an approval. Should the salesperson not have access to that either?
No, the salesperson. Go ahead, Paul.
No, Rich, go ahead. Right.
I was just going to read it again. You said the salesperson shouldn't have credit report info. We aren't getting the report. We are just getting an approval. Should the salesperson not have access to that either?
No, they can have access to the approval as long as it doesn't contain the non-public personal information, NPI, that we talked about. So social security numbers, things like that. If that's on that approval, then no, the salesperson shouldn't get a copy of it. And really, it's kind of a best practice to just keep that information within the F&I office and let the F&I person deal with that. But as long as there's no NPI on it, then yeah, they can look at a copy of it. If it's got information that's public that you can look up on the internet or the phone book or wherever, that's absolutely fine. But the minute it gets into social security numbers, driver's license numbers, things that aren't going to be readily available to the public, that's when it should not be given to salespeople.
All right. In writing our ISP, is there an example of one so I can know if our verbiage is correct? Is there anything out there that either you've seen or you guys provide? Or
well, there's a I would suggest first take a trip to the AFIP.com, and look at the materials that they have there. One of the things that they have that I really like is a complete kit where they give you templates, and you just simply fill in the information about your dealership and everything else that's going on. And again, you can also go to ftc.gov, and they've got some examples of forms there also.
And let's see, by law, how long are we required to keep customers' info before shredding? Is it 5 years?
I don't know. They keep changing that rule and it gets longer. That's an IRS question.
Yeah, and check with your dealership's legal counsel on that one because, again, it varies.
Okay. Are cell phone numbers and emails NPI as of right now?
As of right now, no, but they're looking at it.
Okay. Let's see.
So my guess is that they will be if they're not published.
Okay. Who should take that credit application over the phone? In a lot of cases, it's the salesman in our store.
Rich, you want to take
that? The credit app itself is, again, you're going to have to look at what's on your credit app, but it's going to contain social security numbers. It's going to contain information about salary and things like that. So by the letter of the law, no, the salesman really should not be taking the credit app. Now, I know that puts a burden on F&I to have to take it, but you could also have a GM or a GSM who's working in the dealership handle that information because, again, they're working with F&I to make sure that all of the information is protected and safeguarded, and they're also privy to that information because they're helping to write the deal. So I know it's an inconvenience and it's a little bit of burden on the GMs, GSMs, and the F&I folks, but to the true what they're talking about in the rules and regulations, no, the salespeople shouldn't be taking anything that has non-public information on it, which most credit applications do.
Okay. Regarding the military ID question earlier, just someone from one of the F&I offices, one of our dealerships, there was actually a new act that states you cannot make copies of military IDs, only write down the information. So,
Oh, then I apologize. I have not come across that yet.
Okay, that's helpful to get the word out. What if we get a verbal authorization and the customer was declined? They will never come in to sign. What happens then?
If they never come in to sign, then you still need to send the privacy notice, risk-based pricing schedules, and the normal paperwork out to the customer. And
simply mailed.
Yeah, and I would send it certified, just again to cover. It's like that question earlier about, do I have to give the risk-based pricing to the customer, or can I just stick it in the file? And the correct answer is that the customer is entitled to it. So anytime you're dealing again with this consumer credit, it seems like it's an inconvenience, but better to err on the side of protecting consumer credit and following all of the guidelines, so we don't shortcut anything, and we get it right.
Yeah. Another one is looks like a bit of a follow-up. Our salespeople take the credit app information. Should they not? Should it only be taken by the finance manager?
Technically, yeah, it should be just the finance manager or the general manager, the folks who are allowed to have access to the non-public personal information. And again, if the app that they're taking only has name and address and a couple of other things, which almost all of them don't have just that, then it's fine. But when you start getting into, as I said earlier, social security numbers, income, different things like that, and all of the things that might be on a credit app, then it becomes NPI, and that really should only be handled by the F&I manager or the general manager, folks who would normally deal with NPI in the course of putting a deal together.
All right, and the last one might be a little tricky, just in terms of searching a website, but how can I find the red flags on the FTC website? Or do you have is there a better place to go find those red flags? Or
no, if you want to see the red flag rules the way they're written, which is probably the best place to start, is you go to ftc.gov, and then just at the top there's a search bar. Just do a search for red flags rules, and it will bring up everything on the site, and it'll give you links to all of the different articles, all the different rules, all the different information, and you can go look for what you need from there.
Yeah, and so, if I just did that, it took me about 10 seconds. So I'm on it. The Federal Trade Commission. It brought up the searches for red flags, a how-to guide for business. So
fantastic, easy enough. Well, wow, the feedback today was fantastic. That's all the time we're going to have for the questions. Again, thanks to the F&I department personnel from just a huge number of dealerships throughout the country for participating today. And just Rich and Paul, thanks again for your insight and answering a lot of questions. Again, it was just one person asking, but I'm sure there were many more who had the same question. So, Rich, I'll let you wrap it up here.
All right, great. Thanks, Dave. So, Paul, let's do a couple of key takeaways each and then let everybody go. I think my two key takeaways for this particular webinar is, one, really take a look around your dealership and see where the leaks might be, especially around non-public personal information, or NPI. The second key takeaway for me today to leave with you guys is make sure that all of your employees have been through some sort of training on what's going on, and as you build your ISP, that will be part of the training that goes on there. Paul, couple from you?
Yeah, I think that having the ISP, the compliance manual in your dealership is critical, because from that then you can drive the training, and that will alert you to the different places in your dealership that need to be, kind of shored up. And I'm always going to err on the side of protecting the customer's identity and that privacy information. And I suppose especially literally last month when mine got breached, my radar is up even a little bit more. So it's important. It's something that's being paid attention to. And because we're in the lending or indirect lending business, it is something that's very important for us as dealers to pay attention to.
Outstanding, guys. Perfect way to wrap it up. Again, for the attendees, we'll have the webinar posted on our website here by the end of the day, and then make sure you tell your colleagues at your dealership, whether it's fellow F&I personnel, GM, dealer principal, whomever you think could benefit from all of the above certainly can. And yeah, so just want to thank everybody once again for attending, and be on the lookout for our next Power Sports Business webinar. Take care and have a good day.
Thanks.